presentation for the City Attorney's Office. So if you all stand, please. Ready? Begin. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Anthony, would you call the roll, please?
Yes, sir. Oh, excuse me. Calling roll. Dave Bouvet.
Here.
Brad Smith.
Here.
Anthony Matthews here. Brandon Schindelheim.
Here.
Jerry Askew.
Here.
Bonnie Bursk.
Excused.
Krishna Crawford Velasco. Arthur A. Dausch. Jet Dunlap.
Here. Gina
Gina Greshner.
Excused.
Bob Hudson.
Present.
Suraj Khurana. Sally Kolstad. Joel Lyle.
Excused.
Darren Lopez.
Here.
Bob Lusak.
Excused.
Eric Manska.
Here.
Ross Termel.
Here.
Daniel Wall. Cindy Wu Friedman.
Here.
Debbie Wubben. And Michael Cabo, the parliamentarian, is not here. That I have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, including yourself.
Right. So that's a forum.
Quorum.
So what we're going to do is start with our presentation for the City Attorney's Office. I want to introduce this lady on my left is Elois Phillips, who is with the City Attorney's Office and who is our main contact. And standing to her right is Darren Martinez.
Melvin.
Oh, Melvin, I'm sorry. Melvin.
Haven't seen each other in a couple of weeks.
Right. Yeah.
So good.
Melvin Canis, who is
Yeah.
our Dunn representative and liaison. So, Elois, I'm going to turn it over to you for presentation.
Darren should be on his way. Right,
Darren will
yeah.
be here shortly.
Okay, very good.
Did you want to say anything?
No, that's good.
All right, good evening, everybody. Thank you for having us come out tonight to talk to you about some Brown Act issues and to give you a little refresher course on what the requirements of the Brown Act are as they relate to neighborhood councils. So let me start by kind of giving an overview of what the Brown Act is. The Brown Act, Melvin spoke earlier about that it's a lengthy document. It can be found in Government Code Section 54950. 54950. So if you really want to read it, you can Google it just like that. California Government Code Section 54950, and it will come up and you can take the time to read it. It is California law, it's state law, and it's the law that governs open meetings for local governmental bodies. So City Council has to abide by the Brown Act. All of the neighborhood councils have to abide by the Brown Act. Commissions have to abide by the Brown Act. So the main purpose of it is to make sure that the public has access and input regarding actions and deliberations for, in our case, for the neighborhood councils. Take that on a bigger scale, and it is so that the public can have access to city council deliberations meetings, and so that they can have access and be able to give, get feedback and give input on issues that are before the city council that affect all of the city of Los Angeles. So why does the Brown Act apply to your little neighborhood council? And the reason for that is because your neighborhood council is part of a bigger picture. It's part of the city of Los Angeles, and it's part of their legislative body. And the city council established the charter of the city of Los Angeles and created a plan, which is, everybody refers to the plan for a system for neighborhood councils. And the plan is implemented by a ordinance in LA Municipal Code that says what the powers are, what the rights are, and what it is that neighborhood councils can and cannot do. So because it is part of this global legislative body, it is, and it's certified by the city council, it is subject to the Brown Act. So how does that relate to the neighborhood council in particular? So it affects how you run your neighborhood councils, how you have your meetings, who can come to meetings, who has access, and what decisions are made by the governing body, and whether those decisions can be made in public or private. So we have to look at really what will constitute a meeting of a neighborhood council for purposes of the Brown Act. And so the Brown Act says basically that a meeting happens when a majority of the members of the board meet at the same time and place to hear, discuss, or deliberate on a matter that is in the jurisdiction of the neighborhood council. So you have to kind of break all of that down, because there's a lot of different little points that you have to look at to see when is there really a meeting going on. So your neighborhood council, what is the quorum for your neighborhood council?
11.
11, okay. So whatever the neighborhood council uses as their quorum is the number of people who can take action on any particular issue that's before the council. So if a quorum of your board is together, like we are here in this room, it doesn't have to be in a formalized room. It can be in a park somewhere having a picnic. It doesn't have to be at a public meeting. It could be at somebody's football game. It could be at a conference, or it could be at a retreat. If all of those board members that are there that make up the quorum are there to hear, discuss, or deliberate. So they're not there just for purposes of watching the football game. They huddle together and they discuss an agenda item that's going to come before the board. That would constitute a meeting. If what they're talking about is something that pertains to the neighborhood council. It doesn't have to be something that's going to be on your agenda. It could be anything that is within the jurisdiction of your neighborhood council. So the fact that it's not on the agenda now, if it's an issue that is pertinent or relevant to the community, and you know that at some point it may come before you. If there's a housing development, or a church that's being built, or a roadway that's going to be changed, and it affects your community, it's within your community and it's within the subject matter jurisdiction of your neighborhood council. So a majority or a quorum of your board members would not be able to discuss that if they were at an event other than a meeting like this, because that still constitutes a meeting for purposes of the Brown Act. On the other hand, if there's a majority of your board members that happen to be at a public meeting where there are other public agencies, Department of Transportation, I don't know. You can imagine all the different public agencies that could be there. But if there are other agencies there, it's open to the public, and the board members who do not discuss whatever the issues are that would come before them, if they don't discuss it amongst themselves, then that does not constitute a meeting, and that wouldn't constitute a violation of the Brown Act. When you have committee meetings, committees are also subject to the Brown Act for notice and agenda requirements. So if you have a standing committee, for instance, a standing committee is going to be one that has jurisdiction over a particular subject matter. So if there's a standing committee for outreach, then yes, you would need to post an agenda, and it is subject to the Brown Act. The meeting itself, how it's conducted, would be subject to the Brown Act. Ad hoc committees, those are committees where they're regarding a specific issue, they're limited in time and temporary in nature, and they're advisory. They only report back to the board. They don't really make their own decisions. They're not required to post or noticed agendas, and don't have to really establish a regular meeting time and place. Those committees will usually have less than a quorum. Standing committees, we would hope, would have less than a quorum of board members attending the meeting as well. If you have an informal gathering, Christmas party, where it's going to be a Christmas party where you're inviting all of the board members because they're your friends, and many stakeholders, and you all get together at somebody's house. The board members can't go into a separate corner of the room and talk about neighborhood council business. They can talk about football games, or they can talk about the weather, but they can't talk about items that are going to come before the board. No funding items, no anything that the board may need to take action on. So that kind of informal gathering is not subject to Brown Act meetings. It's not a meeting for Brown Act purposes and doesn't have to be posted.
A question. What if you are a neighborhood council and you're a committee of one? I mean, I'm a faith-based representative. If I talk to anybody, do I have to post that? Or, I mean, at what point, you know?
Ralph, you're not a quorum. You're not all there.
And can you repeat the question? Because we don't hear it on.
The question is, if there's a committee of one person,
Yeah.
can you have a meeting?
Faith-based representative of Granada Hills North, of Hudson is the faith-based representative of Granada Hills South. We talk together, okay. North and South is each is a committee of one. I mean, does that get involved?
There's no such thing as a committee of one, Ralph.
Well, if you're having a meeting with somebody that's outside of your neighborhood council, you're not required to post it
Okay.
for Brown Act purposes. And
There's no action being a conversation, it's not a meeting.
Yeah,
Yeah.
I just want to make sure.
it's not a meeting. It's not a meeting for Brown Act purposes. So if you have a gathering of people and you're discussing something with other people who are not board members and who don't make up a quorum of the board members, then you're not going to be required to notice and post that.
So I don't have to notice any of my meetings. Okay. Okay.
Yeah.
Because Ralph, everything you bring back to your entire panel, that's the public meeting. I mean.
Yes, I understand that.
Yeah, thank you. You're covered.
Even if you're doing it with another neighborhood council member from another neighborhood council.
Okay.
Okay.
Cool.
I have a question.
Okay.
So what is the triggering event? You mentioned if a group constituted quorum went to another public meeting and just listened but didn't discuss things relating to the neighborhood council subject matter, that wasn't a meeting. Is it because that meeting was public and they didn't discuss, or what I'm asking is if, say, a number of us got invited to a land use seminar or something that was a private event, there was more than a quorum there, we listened to the presentation, we did not discuss any subjects that were coming before the neighborhood council, would that be subject to notification? I mean, or could we even attend such a thing?
You could attend.
Repeat the question, please.
Oh, but that's a long question.
Well, you can paraphrase.
Okay, so your question is, can a group of board members go to a private meeting and hear presentation and hear an issue that may pertain to your neighborhood council?
It could. I mean, we could be going to a private function at the police department and hear them talking about plans for community policing.
For Department of Water and Power.
Then that would not be subject to Brown Act notice and agenda requirements because you're not having a meeting.
We're not discussing.
Right, because you're not discussing and you're not forming a consensus on the issues that are being presented. Or the issues don't pertain to your neighborhood council. They're not within your neighborhood council subject matter jurisdiction. So there's several different issues. One is you're not discussing it amongst each other.
And that alone is sufficient, right?
That is sufficient.
Okay.
And that's if it's a public meeting given by somebody else, right? Not a public meeting sponsored by your neighborhood council.
Correct.
Then there's no posting requirements.
Right.
Okay.
How is any of this provable? Like, what about the situation where someone makes materially false statements about something like that? how do you prove that it occurred or didn't occur? How would you defend yourself against somebody who basically makes materially false statements about what you're doing and claims one thing when in fact it was another? How would you as a council defend yourself and prove that no meeting took place? What would we do? It's sort of after the fact. How would we prove it?
Well, jumping ahead a little bit, there's penalties for violating the Brown Act. Some of them are civil and some of them are criminal. And so if you're subject to a court making a determination of whether or not you violated the Brown Act, then you have standards of proof that are different depending on whether you're in the criminal arena or in the civil arena. So for the DA to come and say, you violated the Brown Act because you did X, Y, and Z, then the burden of proof is on them to prove that you did it. So if they have a video, right, that will show something. If they have email communications from several of the board members, that could be used. If they have admissions, that could be used. That could also be used in a civil setting, in a civil court setting, but the standard of proof is less. So you may not have to take your toothbrush in, you know, if you're going to be taken to court civilly. But you could have sanctions or an injunction issued against the neighborhood council, or action could be reversed.
Yeah, but those are the penalties. He's saying, how do you prove that such a thing actually happened? Accusations run rampant. How do you prove it or disprove it?
Yeah, our current situation from a global standpoint in the U.S. is hyperbolic rhetoric seems to drive the political debate right now. And much of that hyperbolic rhetoric is based in lies and misinformation and somebody else's perception of what happened. So I'm saying, as our body, how do we defend against lies? How do we defend against hyperbole? How do we defend against stakeholders or other people that come out of the community and make up reality, and then say, see, this is what they're doing wrong, when we haven't done anything?
Because we took a position on a matter, and they did not like it.
Okay, but that's not like a Brown Act violation.
Exactly. I'm just saying that usually what drives it is you have someone who disagrees with the way the board voted, and therefore they believe that you have somehow violated the Brown Act or something else, when it actually never happened that way at all. We looked at a situation and we decided what was best for our community. We voted a certain way, and because they disagreed with it, they say you cheated somehow. You violated the Brown Act. You did this, you did that. One of the things we're being accused of is the fact that a lot of us belong to different organizations. As a matter of fact, that's how you get elected, because you do represent different groups. Faith-based, other community organizations are represented as it states that it should be to make up the neighborhood council. And because a number of us belong to a number of organizations, somehow we have violated the Brown Act because we all attended those organizational meetings.
Well, whether or not somebody's violated the Brown Act is going to be a determination of the facts, and it's going to be left up to the fact finder, whoever that is. So in proving or disproving it, it's going to come down to whether there's enough evidence to say that the Brown Act was violated. I think what you're asking is, how do you prove a negative? And you can't. So you can only make a statement, make a finding that there was no violation because X, Y, and Z. So if there are members of your board that are together at a meeting, then you probably want to take some precautions so that there's not even the appearance of a violation. So don't huddle together. I mean, it's just kind of like practical things. Don't huddle together where other people would maybe think, take a photograph, or don't put yourself in that position. But otherwise, there's no way that you're going to be able to prove a negative. You're going to have to. It will be, the burden will be on the other person to prove that you did violate the Brown Act.
Okay, yeah,
Okay.
that makes sense.
Okay, so another type of meeting for Brown Act purposes is a serial meeting. And serial meetings under the Brown Act are absolutely not allowed. So what is a serial meeting? A serial meeting can be when A calls B, B calls C, C calls D, and so on, until everybody on the board has been reached about a particular issue or item that is going to come up before the board. And that is done outside of a regular meeting so that the public isn't aware of the discussions, the thought processes, and how a decision has been made. So those are forbidden by the Brown Act. Telephone calls, emails, text messages, even using a third party to say, like, you know, somebody's wife calls everybody to say, you know, are you going to be at the meeting tomorrow, because we really need to discuss whatever the agenda item is, and I kind of want to know how you're going to vote on that. Those are all examples of serial communications that are forbidden and prohibited by the Brown Act. And the real reason for that is because the Brown Act wants to foster transparency and input and involvement from the public. And when issues are conducted behind closed doors, then that can't occur. So so you want to be careful when you're having any kind of gathering amongst neighborhood council board members, so that it's not taken as a meeting. If it is a committee meeting, there does need to be notice, and there are posting requirements for committee meetings, for standing committees, and for your general meetings or your special meetings. So the Brown Act says that there are several rules that govern the conduct. And that is, under your regular meetings, the Brown Act says that you have to have a regular time and a regular place to have your meetings. the plan says that you have to have them at least quarterly, but the Brown Act says you have to establish something that the public will know, you know, for certain when they can expect to have a meeting for your neighborhood council. Your bylaws establish what the frequency of your meetings are going to be, but the Brown Act governs that you will have a general or a regular meeting on X date, 4 times a month, or 4 times a year, excuse me, or once a month, whatever it is. Your meetings, yes?
Does that also apply to committee meetings?
Standing committee meetings should have a regular time, but ad hoc committee meetings do not.
I got a question. I'm chair of the bylaws. We don't have that many changes for bylaws, and it's a standing committee, but the necessity of having a monthly or even a quarterly meeting is mostly unnecessary. In fact, we're waiting to have another bylaws meeting, but we're also waiting for Dunn to settle some things that will be added to our bylaws. In fact, they've come out and made those statements to us. So it's no use having a meeting if you can't establish something that will stand the test of time, because the supervising body above us may come along and change that. So there may be exceptions to that standing rule on when you're going to have a meeting.
For standing committees.
For certain standing committees. Others, we have regular meetings, but there are a couple of standing committees that you just don't need to have a lot of meetings.
Same thing with the budget committee.
Okay.
There's not a need every month or every quarter to have that, so it's nothing meaningful is going to come out of it.
Well, it's also covered at the general meeting, your budget.
So is it not the case then that you need to have a regular meeting for every standing committee?
I'm going to refer that to Dunn, to Melvin,
Okay.
and Melvin can answer that question.
Well, according to this, it says standing committees and temporary committees that are subject to the provisions of the Act do not need to establish a regular time and place for their meetings. That's in this,
Well, so the Brown Act establishes that boards, governing bodies of a permanent nature, of a standing nature, therefore standing committees, need to meet once quarterly.
So the definition of a standing committee is not just any other committee other than an ad hoc. There's a special definition then for a standing committee. What is that definition?
That you're dealing with matter of a permanent nature. That is not a temporary matter.
Okay,
so public safety, for example, is a common, transportation committee. One common practice that neighborhood councils do is that, particularly for elections committees, bylaws committees, those are not, you don't have to make them standing committees. You can make them ad hoc committees and allow the board the opportunity to call it, to activate it as necessary.
Oh, okay.
Okay, so, and to give it a set amount of time. So for the next 3 months, we're gonna call the ad hoc bylaws committee to review our bylaws for possible amendments. Now, there's budget and then there's finance committees. So I don't know how you use it. I mean, budget, depending on how you use it, it could be something of a standing nature, of a permanent nature, in the sense that every month there has to be a report to the board. Now, it doesn't mean that it has to go through a committee like that. It could be the treasurer doing it on his or her own, or a finance committee doing it. So there's ways to work around it. Not everything has to be a standing committee.
But let me just explain for our purposes here. We have about 6 or 7 standing committees. We have, just off the top of my head, our Plum Committee, which normally meets every month. We have an Outreach Committee, which doesn't meet every month, but meets fairly frequently. We then have things like the Beautification Committee, the Budget Committee, the Bylaws Committee, Planning and or Public Safety and Health. All of those committee meetings are as needed. In other words, as subject matter comes up, they meet. So would it be your suggestion that we turn those into ad hoc committees rather than standing committees?
And Darren Martinez is here.
Hi, everybody. Let me just introduce myself. I'm Darren Martinez. I work with the Lois, and I want to just kind of jump in and help answer this question.
Get closer to the microphone.
You know, what you're talking about, with your board, you have to have a standing rule that establishes what your regular meetings are, okay? So you say on the first and third, you know, Tuesday of the month, whatever it is, all right? That's your rule. That's your rule for your board meetings, all right? Under the Brown Act, whenever you notice any meeting of the standing committee, you give the 72 hours, it presumes that that's the regular meeting of your standing committee. Okay, does everybody follow? Mm-hmm. All right. So your standing committees, they do not need to have necessarily a fixed schedule for their meetings. They can meet on an as-needed basis whenever you're having issues that come up. But remember, the Brown Act's purpose is to kind of have those meetings regular meetings. So if you notice it, there's a provision in the Brown Act that says it presumes that when you've noticed it with the 72 hours, your standing committees, that that's going to be a regular meeting of the standing committee. Most of your committees are going to be standing committees. Almost every one of your committees are going to be standing committees, and they're going to have to follow the notice and posting requirements. There's a very small exception under the Brown Act for what's called ad hoc committees. Now, the ad hoc committees have to meet a very specific time frame. You can't just have a bylaw ad hoc committee. You have to have you could have a committee that goes out to research possible grievance procedures to include in the bylaws and report back to the board